Okay, so I think we'll make a start. So welcome everybody. My name's Adam. I'm one of the founding members of the PBA, and I'd like to welcome you to this HR Essentials webinar for payrollers today. It'll be myself and a colleague of mine, Donal Moon, who will be presenting. Donal will be presenting most things. But hey, if you can move the next slide on, please, just to show people who we are, so you can see who we are. So Donal is an employment law consultant who works within the HR consultancy team of Moore Kingston Smith, my old team, before I moved across to head up the Payroll Bureau. So on today's agenda, I'll just give you a brief overview as to who is Donal and what his background is. And then he will be going through the impact of COVID-19, which I'm sure many of you will already know. He'll be giving you an update on the Good Work Plan. He'll also be talking about the changes to the holiday reference period, and I'm sure many of you are already facing the headache of the changes that's brought recently. He'll be also talking about the changes to termination payments and the taxation when it comes to pay in lieu of notice and redundancy. He'll also be talking about breaks in continuous service. I'm sure many of you, like myself, get asked by clients, oh, how long has there got to be a break in someone's service in order for it not to be continuous? So he'll be giving you an update on that. And then we'll have question and answers at the end, which can cover anything that we will have covered in the agenda, or it can be any other payroll/HR related questions that you may have prepared, and we'll do our best to answer them. So, who is Donal? So, Donal is, as I mentioned earlier, is our employment law consultant at Moore Kingston Smith. He joined about 6 months before me, back in 2014, and he supports clients by advising them on unfair dismissal, breach of contract, wages claims, TUPE, discrimination, whistleblowing, and settlement agreements. He is an ex-practicing solicitor and gave up his practicing certificate in order to move across to the HR consultancy team. But he also works with all aspects of defence work to claims made against employers in employment tribunals. Thankfully, and touch wood, we haven't had to deal with many of those over the last couple of years. But we do get them every now and again where an employee is chancing their arm, puts in a claim, and we support our clients and employers on that. And what he tries to do is he focuses on arriving at the right answer to legal questions and gives clients legally and commercially sound advice. Not saying that he's not risk averse, and not saying he's also a cowboy that will just give you any answer. At the end of the day, dependent on the client and what their outcome, he'll try and get them there as legally as possible without breaking sort of any laws or anything else like that, so that sort of from a legal standpoint, they've met everything that's needed, but also commercially, if it's more commercially viable to pay out a settlement because the cost of defending the claim will far exceed that, then that's the sort of advice that he'll give, rather than just being risk averse and going, no, this is exactly what you need to do. So that's Donal. I'll hand over to Donal now, and he'll kick things off with COVID-19.
Thank you very much, Adam, for that update, for the kind introduction, and hello everybody, and thank you for logging in this morning to hear the HR Essentials for Payrollers. So I hope you find today useful and informative. There's been loads of developments to talk about, so I'm going to do COVID-19 briefly, but you're probably pretty painfully aware of COVID-19 and the impact that it's had, so I'm going to focus on that very briefly before moving on to the main thrust, which will be the Good Work Plan. So for those of you who aren't aware of the Good Work Plan, it's the plan that the government brought in response to all these cases, like the Uber case, where people were claiming to have self-employed contracts, but actually it was turning out those people were workers and probably being exploited. So that will be the main thrust, so some of the big changes that have come in around that. But okay, starting off with COVID-19, I think to say that that's had a massive impact on everyday life it would be an understatement, but employment law is no exception to that. So some of the big impacts that we've seen so far is gender pay gap reporting obligations for this year have been postponed. Reports not now due until next year. Some companies, you may still be getting requests around this because some companies are choosing to report anyway, even though they don't have to. the problem with next year's figures, of course, is that anyone on reduced pay must be included. Must be excluded from the reporting. So you can imagine that could exclude a lot of people who are on furlough. So I'm not sure how useful next year's figures will be, but nevertheless, the next report is due next year. The long-awaited IR35 change is also postponed until next year. If they ever get brought in at all, I'm assuming they will be. The government seems quite resolute about that, but we'll see. It's kind of one of those watch these space moments. And the Coronavirus Act 2020 brought in a lot of new rules and regulations in relation to a lot of different areas. But from an employment law perspective, it brought in two interesting things that probably impact you. So firstly, you've got the new concept of emergency unpaid volunteer leave. So you might be asked to run something around that in payroll, or explain any gaps in employment that may exist. But also SSP became claimable from the first day of incapacity for the first time, and that was with retrospective effect back to the 13th of March 2020. And then, of course, the big one, the introduction of the Coronavirus Job Retention Scheme. That's, of course, the government scheme to try and encourage employers not to make any rash decisions, not to proceed with redundancies, but instead to retain their staff, potentially place them on furlough and receive government support for the wage costs to an extent. So it was 80% of the wage bill at one point, and with the companies having the option, if they wanted to do so, of topping that up themselves. That support now, of course, tapering down, and the scheme will be ending in October at the end of October 2020. Can I have the next slide, please? Thank you. So we've been getting a lot of questions, as you might imagine, around furlough, and I imagine you've been getting the same, but here's some of the common ones that we've had. So redundancy pay, of course, the conversation now, unfortunately, moving from keeping people on furlough to considering redundancies. So questions arising about how redundancy pay should be calculated and whether it should be based on an employee's full pay or the reduced furlough amount. Actually, it's been confirmed now that it should be on the full pay and not the reduced furlough amount, and that's consistent with the approach the courts have taken in cases of say short time working. You just ignore the time spent on short time working and concentrate on the full ordinary pay. One interesting question that we got recently was actually an employer who hadn't used furlough because they still needed employees to do the work, but at the same time they couldn't support the full wage costs, so they used pay cuts instead, and they asked if in those circumstances it might be possible to use the reduced rate. Legal position a little bit unclear in that respect, but the conventional wisdom with legal commentators is that should still be based on full pay also. The principle is the same, and the way the courts are likely to interpret it will be in a fairly claimant-friendly way. And what they're likely to say is that an employee may well have agreed a pay cut, but that was probably only ever on a temporary basis, not on a permanent basis. So once the situation changes and you move on to redundancy, you then obliged to pay at the full pay rate rather than that reduced pay cut rate. Interesting clarification very recently from the government about what the scheme can be used for, to pay for, and what it can't. It's now been clarified it cannot be used to pay redundancy pay or payments in lieu of notice. But of course it can't, because the spirit of the scheme is to try and keep people employed, not to allow employers to dismiss and for the government to pick up the tab. But what it can be used for is to pay notice. So in some cases, so for people who are still employed, so what we've been advising in some cases is that it may be to the employer's advantage to either keep the employee on furlough if that's possible, or place them on gardening leave, and then it may be possible for them to make a claim from the scheme. In those respects, because they're still continuing to pay an employee. Another interesting point is about whether employees can continue to do work for a company that furloughed them or not, and what constitutes work exactly. There's a little bit of lack of clarity about whether consultation meetings and employee representative activities could still be carried out without breaching furlough rules, and it's now, of course, been clarified that they can. Yeah, that doesn't count as work, so it won't be breaching the scheme. Could I have the next slide, please? Thank you. So moving on to the good work plan. So I think as the slide kind of says it all, it is the gift that keeps on giving. This was the government's response to multiple cases involving big brand names that you're probably aware of, like Uber, Lyft, Hermes, and Pimlico Plumbers, where they were claiming that they were engaging self-employed contracts, but was actually happening when you dug a little bit deeper. These people were not self-employed contractors at all. They were workers or employees. So the government introduced a raft of measures to deal with this, and it's been causing a little bit of confusion as to what parts of this are in and what parts are out, because it seems to be implemented at various stages. So I'll just give you a snapshot of what's in and what's awaited, and then I'll move on to discuss the provisions in greater detail. So what's in? You've got the changes to the information that must be included on payslips. Now, I'm not going to go that into much detail because you probably know more about that than I do. Changes to the holiday pay reference periods, which I'll come on to. There's now a day one right to the written statement of the main terms of employment, which I'll come on to. The abolition of the Swedish derogation, which relates to agency workers, and I'll cover that in more detail in a moment as well, and the right of agency workers to a key information document about their key terms and conditions. So the bits that are awaited, and I think this is what some people thought some of these things were in already, but they're not yet. They're just awaited. So again, it's a watch this space moment for that one. They are going to come in, but we just don't know when. So they were looking at employment status frameworks for employment rights and tax. So what they're trying to do is to align the approaches that's taken to deciding whether someone's employed, self-employed, or a worker. Because at the moment, you've got this bizarre situation where HMRC publishes a checklist, which you can use to see whether someone's likely to be self-employed or a worker or an employee. But you could get a very clear answer from that. But when it goes to a tribunal, an employment tribunal, for example, the tribunal might come up with a completely different answer. So they're trying to look at ways in which this might be, the approaches might be aligned to make it clearer. Still consultation going on about that. There'll be a new enforcement regime for statutory holiday pay. There'll be a right to request a more stable contract for 0 hours contractors. And there will also be new rules about breaks and continuous service. Now I will cover that because it's still, I think as Adam mentioned earlier, it's still an interesting point that you get asked quite a lot, how much break do I need to have? So I think I'll cover that in more detail in a minute. So holiday pay, some key changes with that, and I think they're for the better, to be fair. So from April 2020, the reference period for calculating holiday changed from 12 weeks to 52 weeks. And I think the reason it makes sense is that A, 12 weeks was a payroll nightmare anyway, I should imagine, having to do it on that basis. And B, it didn't take into account peaks and troughs in the work, especially when you now have to factor things in like commission and overtime into calculating holiday pay. So I think 52 weeks does kind of take care of that in the sense that it will give you a more true average probably of what's been earned and worked over the space of an entire year. But it applies. What does it apply to? So it applies to holidays taken on or after the 6th of April 2020 only, and it only applies to holidays taken by workers with irregular hours or pay. And again, it only applies to holiday from the statutory 5.6 weeks entitlement. So anything over and above that, you're looking at what's in the contract of employment and how the contract of employment deals. Most employers will probably try and be consistent and keep it as 52 weeks, but you may get some contracts of employment that contain provisions which try to limit liabilities in some way. So worth checking the contract of employment just to see what the provisions are, if there's anything different in relation to holiday over and above the statutory entitlement. And also excludes the calculation must exclude weeks where no pay was received. So I'll come on to the calculation in more detail in a second, but if I can have the next slide, please. So in terms of enforcement, the government's planning an HMRC-led regime. So there'll be firstly it'll be a two-step approach really. It will be an awareness campaign to make employers aware of the need to calculate holiday pay on the basis of the 52-week reference period rather than the 12. Most employers, again, I should think will probably be aware of it, but there will always be some that slip through the net and aren't aware and start calculating incorrectly. And then there will also be enforcement powers for HMRC. So it will be presumed, we don't know what those will be yet because it's not been clarified. But I imagine it will be a little bit like the National Minimum Wage enforcement powers, where they can either publish a name and shame list of employers who fail to comply, or they can order the payment of the correct sums to the employees. But that's coming shortly. So how do we calculate all of this? So for the statutory, remember this is the statutory entitlement only. So what you do is you go back 52 weeks, and it's from the last complete working week ending on or before the first day of leave, starting from Sunday and ending on Saturday. So it's not entirely, it's not very easy to follow, but hopefully that sort of a bullet point will help you do that. But you also exclude any weeks that weren't worked, and that's a good thing too, I think, because it covers those employers who may work seasonally or may shut down for certain periods or be less busy. But if you have below 52 weeks, so you don't have 52 weeks to enable the calculation to take place, you go back further, and you can go back as far as 104 weeks to get 52 weeks. And if you're still below 52 weeks, if you try that exercise, so say, for example, if someone doesn't have enough service, then you just use the number of weeks that you do have to do the calculation. And for anything over the statutory entitlement, you see the contract of employment. That will be the key document to look at. What does the contract say about how holiday over and above that statutory entitlement is calculated? Can I have the next slide, please? So one massive change, and you've probably seen some of it coming in already, but not all of it. Now things are really gathering pace is in relation to termination payments. The HMRC and the government are resolute about making sure that employers pay their tax, employers and employees pay their the full tax and NI that they owe. And what they don't want to enable is a situation where employers pay what should be taxable termination payments and wrap them up as ex gratia payments dishonestly to try, or accidentally even to try and avoid paying tax. So they brought in this new regime about that. So the first point to note is that genuine ex gratia payments can still be made tax and NI free up to £30,000, and statutory redundancy pay can still be paid tax and NI free. One point to note is that if you're making both, so sometimes an employer might say, I want to you're making some redundancy, you give them their statutory redundancy pay, but you also want to pay an ex gratia payment. So it's the combination of those two tax-free payments that the 30 applies to the combination of the two payments, not to each payment. So it's anything in excess of the £30,000 that's then subject to the tax and NI. So you can't treat them as two individual things. This may sound like a silly point, but taxable termination payments cannot be made tax-free, and the three big ones that come to mind are salary, accrued but untaken holiday, and notice pay. So you might think that's obvious. Why would every employer want to do that? But unwittingly, the employer can land themselves in a lot of hot water from trying to do one thing or another that isn't quite right. And this is where I think as payrollers, you can kind of start digging into it with questions to kind of make sure that they are paying everything they owe, or whether they might have additional liabilities that you can then either seek employment law advice or refer for employment law advice on, or tax advice as appropriate. Could I have the next slide, please? Thank you. So the common issues we see are some employers assume that it's still okay to pay notice pay as damages for breach of contracts. I don't know whether any of you have ever seen this before, but in some cases, what employers used to be able to do was to say that they weren't going to allow the employee to work their notice, and therefore that was a breach of contract, and they'd pay the notice as damages on a tax-free basis. That's now no longer possible following the 2018 changes. It's an absolute no-no. And the other thing is, so it must be subject to tax, and we'll come on to that in a minute when I discuss the PENP rules. The other one we see quite frequently is the employer will just approach you and say, I want to make a payment. I want to make an exit payment, and they'll just give you a broad figure, so one single figure. And when you sort of drill down a bit further and say, okay, what about notice pay? What about holiday? It turns out they want to include everything, but they want to do it all tax-free. Well, of course, that's the point when you say, well, actually, that's not possible. Some of these elements will be taxable. But it's worth questioning that for sure. But I think when someone sort of just gives you a broad brush figure, what are you going to do about the other taxable payments? Because it just covers that base and tells you when it might be time to refer the matter on for more expert advice if necessary. Another one we see is where notice either hasn't been issued at all or properly. It might seem a bit weird saying notice hasn't been issued at all. But one that we see quite frequently is where the employer and the employee are talking about a termination package. So things are moving along quite amicably, to be fair. It doesn't always have to be a dispute. But so actually, and they're assuming that the employee, it can just all be wrapped up, but actually there's not been actually any formal notice issued. So there's just in discussions and nothing's actually happened. Or it could be that notice hasn't been issued properly. So say, for example, if you look at the contract and it says that notice has to be given in writing, but actually it's been all done verbally so far, that might not have been given validly. So in those circumstances, the problem is, of course, if that hasn't been done, then if you try to make an ex gratia payment without that bit having been dealt with, you will have to either pay notice on top or some of that ex gratia payment will be taxable. It will be construed as notice. The other big one we get is, I don't know if you've ever seen this before, where an employer miscalculates notice, and you would think that would be difficult to do, but the most common one we find is the old contractual versus statutory debate, where you've got an employee, they've got, say, 1 month, 2 months notice in their contract of employment. But actually, when you question it further, you look at the contracts, think this guy's been here for 15 years. So 1 month or 2 months is not their actual entitlement, it's the statutory, because you have to go with the greater of the statutory or contractual. So actually what they're entitled to is 12 months. You plan to pay them 1 month. So it will just be inferred that actually you've only paid a portion of this notice pay, so therefore some of the ex gratia is also the bit of the notice pay that you haven't paid. And yeah. So can I have the next slide, please?
Sorry, just to jump in and correct you, just in case anyone does pick up on that, it's 12 weeks, not 12 months.
Oh, sorry. Yeah, that's
statutory notice.
I did mean 12 weeks.
Wishful thinking, perhaps.
Well spotted. But yeah, no, it would be, yeah, wishful thinking indeed. Okay, so termination payments post April 2018. So this is when the PEMP calculations came in, and this is why those issues that I've just mentioned are now starting to become a problem for employers who don't do things correctly. What HMRC will look at is how much of the relevant termination payments, so that ex gratia payment, is actually post-employment notice pay. And that's then subject to full tax and NI. So when you calculate, it's a basic calculation. We have accountants here at Moore Kingston Smith who run the calculations for us. But it's basically the basic salary the employee would have received during the unworked notice, less any contractual pile-on received. So again, if you haven't got your house in order in terms of the notice pay that you make, again, you're probably going to have to perform that calculation and apply some tax to the ex gratia payment. One more change was introduced in 2019, that the first £30,000 was eligible for the tax exemption, but only the employee is exempt from national insurance contributions. Beyond the £30,000, the employer must pay it after that point. So what I often do when I get questions about termination payments, and they often come up in the context of settlement agreements, is I've got a list of key questions that I ask to try and help me establish the facts and sort of try and keep the client out of hot water, or know when I have to refer something to tax for advice, or an accountant, or payroll even. So firstly, the first thing I do is I try and get hold of a copy of the contracts of employment so that I can just check the length of service, the notice provisions, and things like that. I would then look at, and again, as you know, the holiday pay provisions. I would look at how the employment was terminated. So what exactly is going on here? Is this a mutual agreement termination? Is it going to be a termination with notice? What exactly is going on? Is there documentary evidence of the notice that was given or the resignation? I'd ask whether the employee is working their notice or whether there'll be a pile-on. Because if they're working their notice, that's great. But again, it goes back to whether you've got evidence of that, because you won't be able to, the client won't be able to backdate a notice, a termination letter. It has to be done at the time. You can't really do it with retrospective effect. Or will there be a pile-on? Will the ex gratia payment be in addition to or including the notice or pile-on? So if the employer hasn't explicitly said to you that, okay, I want to make an ex gratia plus pile-on plus accrued holiday pay, so that immediately sparks the question, like, what exactly is happening to those two potential taxable elements? So that's the point when they'll tell you what exactly they want to do, and you can start sort of analysing whether some of this whether all of it can be paid tax-free or some of it might have to be taxable. And was any or the correct notice given? So again, that's comparing firstly the statutory to the contractual entitlement, making sure that's right, and then seeing what's happened in terms of giving notice, and then if you have to do a PENP calculation because you think some of the ex gratia, some of the notice isn't right or hasn't been given at all, that's when you would refer it to the tax experts to do a PENP calculation if you need to do so. So breaks in continuous service. So this is quite an interesting one because it can arise at either end of the employment relationship. So sometimes you've got someone who does, say, I don't know, voluntary work or some agency work, and then that sort of morphs into a full-time contract. And it can happen at the other end of the relationship where you end someone's full-time employment and then you re-engage them, say, as a consultant or as a worker or in some other form other than a full-time employee. So if the two relationships are kind of seamless and there's no break, then sometimes there is a risk that it could be conferred as continued employment if either HMRC contest it or if the employee contests their employment status at the tribunal. So what we always suggest is there should be a break between two relationships to make sure that doesn't happen. So that is going to change to 4 weeks, and some people were of the opinion that change had already happened. To be fair, it's not the worst mistake you can make because the longer gap, the better. But actually, that's not come in yet. It's coming in shortly, but for now, we're still recommending the same as we always did, which is a break of more than 2 Sundays to ensure a break in service. Because really, what it wants to be longer than a break that you could potentially explain away as a holiday, if possible. I think that's a good way to see it. Unofficial service, of course, yeah. So that's it, and watch out for say voluntary service or unofficial service followed by employment as well. So that's where you might want to be advising someone if you're aware that something like that exists. That have they thought about having a break between the two relationships to try and reduce their risk? But these break in service cases can be quite interesting and difficult because sometimes it can mean the difference between someone having sufficient service to pursue an unfair dismissal claim or not once the employees started to accrue service. Okay, so there's been lots of changes regarding agency workers, as you expect. That's one of the big reasons this was all brought in the first place. Some of the kind of dodgy practices that are going on with companies like Uber around claiming to be self-employed contractors, but the government's also concentrating on agency workers, and particularly 0 hours contracts, as it regards those people as particularly open to exploitation. It had been thought that the agency workers regulations might well be a casualty of Brexit, but it doesn't look like that's the case. If anything, the government's looking to strengthen up agency worker protections. Just for those of you who are unfamiliar with the agency workers regulations, because there's not much case law around it, and it doesn't get much press, but they basically give agency workers the same right to the same pay and conditions as a comparable direct hire with the end user employer after 12 weeks continuous service. So that's fairly easy to understand, I think. But there was an exception that allowed employers to pay agency workers between assignments in return for them signing away their rights to equal pay. So there was a carve out for pay and that was what was known as the Swedish derogation. That's now being abolished. So after 12 weeks, agency workers would also be entitled to equal pay with comparable direct hires. And the other thing they have is that they'll have is the right to receive a key information document, and that's a document that will be setting out the key terms of work, and that has to be given before they sign up with an employment agency. It's really employment agencies that need to worry about that more than anybody else, but they still need to get them. So it's worth being aware that they do have that right, because it may be that when you're asked to run payroll and you ask for copies of that, it's not there, and you can maybe sort of tell the client that they might be in breach, or refer them on for further advice. Stable contracts. A lot of people misconstrued what was in the Good Work Plan as assuming that people had the right to a more stable contract. They don't. They have the right to request a more stable contract. So this is again for 0 hours workers and agency workers, and they accrue that right after 26 weeks service. Unfortunately, there is no guidance at the moment about what the stability will be. So it's probably lucky that this hasn't come in yet, so because there'd be a lot of clarification required around that. But I imagine it will be in terms of hours and salary and overtime and those type of key things. That's the only thing I can think of at this point. But yeah, so the employer doesn't have to give a stable contract, but they have to consider the request and judge whether it's reasonable to grant that request. So there's still some flexibility for employers to deny this request, but they just have to consider it reasonably and be able to back up their decisions with evidence. So I think that brings me to the end.
Yes, thanks very much, Donal. You've covered quite a lot there, sort of in the last sort of 25 minutes or so, and really just want to sort of ask if people have any questions about anything that Donal has raised or any other HR and payroll related matters. If you can use the raise hand bit on the bottom of your screen, or if you click on the more bit, and then what we'll do is Haig, who's in control of everything, will then help unmute you so that you can ask your question, and we'll do our best to sort of answer anything that we're unable to answer today. We'll go away, look up, and then we'll post the question and answer in the LinkedIn group, and hopefully try and tagging you in it as well, so that you get notification that your question has been answered, and you can then log into LinkedIn and view that. So really, over to you guys to see if you have any questions at all.
We've got a question from Fiona, so bear me a moment, Fiona. I will unmute you. Not let me unmute you. There we go, Fiona. You should now be unmuted, so please feel free to ask the question.
Yeah, I've been asked a question by a client. Can they receive their redundancy pay over a couple of months so that it doesn't push them into the higher rate tax?
Oh, that's more of a tax question than an employment law one, to be honest. But
okay.
I mean, sorry, Donal. I mean, I can understand the lump sum being sort of in one particular month, but regardless, if it still falls within the same tax year, even if they're splitting it out over a number of months, it's still going to be recorded sort of on their year-to-date figures. So may well do. However, by doing it over sort of 2 or 3 months, it may just mean that that final month tips them over, so they'll only be paying a little bit of higher rate tax in that final month, rather than high rate tax sort of on everything if it's done as a lump. So yeah, as Donal said, perhaps speak to sort of, if you're part of an accountancy firm, speak to someone in your tax team. But really, it's more for the employer and the employee to actually agree to how payments are made, and I think that's probably the key thing. If they feel that they're going to sort of get away with paying less tax, as long as everything's processed through the payroll correctly and there's documentation showing that both the employee and the employer agree to that, because most employees like to have all of their money sort of up front so they can just cut off things, because effectively the employer will have to keep that person on payroll for that much longer, because if you terminate someone and then pay them afterwards, obviously it'll be deemed a payment after leaving. So that's the only thing you have to consider. It's more, if the employee and the employer agree to it, then I don't see it sort of being too much of a problem. You've just got to understand the implications of keeping them on the payroll potentially a bit longer, and because their termination date then may be pushed for 2 or 3 months. If it's been done that, then obviously they maintain their employment rights during that time and potentially would accrue holiday and everything else. So there are other implications to prolonging things longer than needed.
Yes, that's what I thought. Thank you very much.
Thanks for your question.
Thank you.
Bear me a moment. We've got another question here from Reese. Bear me a second, Reese. I'll unmute you. You should now be able to answer the question.
Just with regards to the holiday reference period, 52 weeks, if employees have been on furlough, would you include those in the 52-week average, or do you have to go back further? Because they would have been receiving reduced pay. I know that for the maternity and etc. calculations, you need to use the ordinary pay. But
yeah, that's right. So you'd still need to top it up to ensure that they're receiving full pay for their holidays. So yeah, you still have to, yeah, you'd have to pay make sure that the holiday pay rate was based on ordinary remuneration. So that would discount the period of time spent on the reduced pay rate.
Okay.
Either that, or you would top it up in some way to make sure that happened.
Yeah. All right. Thanks.
Thank you, Reese. Are there any more questions at all?
No.
No more questions? Okay, we move on. Thank you very much. Adam, did you want to speak about this, or myself?
No, I'm more than happy for you to take control.
Okay, so as some of you may or may not be aware, it's National Payroll Week next week. I'm sure you are. And obviously the PBA are running their superhero campaign. We're delighted to say that we've had 11 come through, and we'd just love to see a few more posted on the community LinkedIn group. You know, it can be anything from a vegetable to a fruit to a tin of beans, whatever you want to dress up as a superhero. You all deserve that recognition. It's a bit of fun. So please get involved, post them in that group, and we'll look to put together some sort of montage, or if we can, a small video towards the end of National Payroll Week and post that for everyone to view. It's nice to see so many people get involved. And yeah, please continue to send them through. It's nice to see that the payroll industry is being recognised, and to be a part of the National Payroll Week 2020 and promoting what we do. And finally is our next webinar, which will be on the 8th of October at 2 o'clock, which is Building Better Bureaus. And that's with Adam Coyle and Annette Gibbons. So redesigning for post-COVID deployment, which should be an interesting one. Note the time change. We're going to run this one in the afternoon at 2 o'clock. So if you've got any questions or around that particular webinar prior to it happening, then do drop us an email on the email address listed on the slide, or if you're happy to wait, then wait for the link to be registered, and we'll get that posted out on the groups in the next couple of weeks or so. Thank you very much. And just a final thank you to Donal and Adam for today's webinar. I hope you found it informative. If you've got any feedback, again, please feel free to contact myself directly or one of the founding members, or to send an email into Payroll Bureau Association @gmail.com. So thank you very much.
Thank you.
Thanks, everyone.
Thanks for your time.